gun rights lawyer Alan Beck on historical evidence those under 21 bought guns at the founding, plus his latest fight at the Supreme Court. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of thereload.com, where you can head over and sign up for our free newsletter today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on reporting and analysis instead of, opinion. And I keep trying. I need to come up with I say hot air, and I want to change that. Opinion and bluster. Would that be a good one? I don't know. You guys tell me. Anyway, this week we are talking with gun rights lawyer Alan Beck about really an interesting sort of legal argument, a new legal argument surrounding the gun rights of 18 to 20-year-olds. And so welcome back to the show, Alan. As sort of one of our working gun lawyers. We have a lot of gun scholars, academic types on the show, and I think it's good and refreshing to have somebody who's, actually in the courtroom doing this work on a daily basis, maybe a little bit of a different perspective there. So I appreciate you being here and welcome back to the show.
Thank you for having me, Stephen.
Yeah, absolutely. For anyone who doesn't know, can you just give them a little bit of a refresher on your background?
Well, I've been a practicing attorney since 2009. I'm licensed in California and Hawaii, and I'm also licensed in a few other federal courts, including the ones in D.C. And, I actively practice law in D.C., California, and Hawaii in federal court. And, I'm not doing, Second Amendment law. I work in a few other areas, including, personal injury and other areas of civil rights litigation.
Mm-hmm. And Hawaii being one of the key states in the fight over gun rights in the United States, I think you've had quite a lot of cases over the years where you've kind of set the standard. I mean, you're kind of one of the only lawyers who's doing work on the gun front in Hawaii, right?
That's correct.
Sorry. No, go ahead.
There are a couple other people that I work with, but there's no one that is licensed Hawaii that's actively doing Second Amendment law apart from me and my colleagues.
And that's led to a number of pretty prominent cases that you've been a part of coming out of Hawaii, like the Young case years ago, and a bunch of other ones. But most relevant to what we're going to start off here with is a case that you have dealing with restrictions on guns for 18 to 20-year-olds, right? Can you tell us a little bit about that one?
Well, first, I'd like to note that I'm here on this podcast in my personal capacity, and the views I espouse share my own. However, I am representing a number of clients, including the Second Amendment Foundation, in a challenge to Hawaii's ban on young adults between the ages of 18 and 20 owning firearms in the state of Hawaii. And the name of that case is Pinales v. Lopez.
And you've had already one ruling in this case that didn't go your way, right, on the preliminary injunction. But maybe, oftentimes when we see one side lose on a preliminary injunction, you think, that's probably it. You're not going to pull it out in the merits part of the case. But there may be some reason to think otherwise in this one, right?
Yeah, I mean, the judge is very clear. It's a fairly old law. I mean, there's a couple new ones, but the main ban on firearms is about 30 years old. And the judge, she wasn't ready to make up her mind, essentially, and she made it very clear in her ruling that she was amenable to issuing a different outcome once there's been a fully developed record. And so that's what we're doing right now. We've started getting the process of litigating the case to the merits in Pinales. And we've to be fair to her, we have done a lot more research on the history, as presumably has the state, and she's. We look forward to going to a summary judgment sometime in the near future.
And one of those areas of research, right, is kind of a new argument in this space, this issue of gun rights for 18 to 20-year-olds, which has been, an active fight in the courts all over the country for quite a while now. Even pre-Bruen, you saw a lot of cases surrounding this question of, what gun rights to 18 to 20-year-olds have, what restrictions are allowed under the Second Amendment and what aren't. And we actually just got a major ruling on this out of one of the appellate courts, the en banc court, the full court, in other words, of the 11th Circuit, ruled in NRA v. Bondi, which is a case out of Florida, referring to then Attorney General of Florida, Pam Bondi. Now she's the U.S. Attorney General, but that was over Florida's ban on the sale of guns to anyone under the age of 21. And the en banc court, maybe a little bit surprisingly, upheld that law. And what was most interesting about their ruling, right, was the standard that they used. It's sort of a new take on this whole fight, where they argued that during the founding era, essentially anyone under the age of 21 was considered to be below the age of majority, or in other words, an infant, as they would have been called at the time, which meant that they didn't have the authority to buy guns. That was the basic holding in that case, right?
Essentially, except rather than buy guns, the court said they didn't have a right to contract to buy guns, which is a little bit of a distinction. The court made its premise on the idea that most gun sales, if not all gun sales, were done in some form of contract. So you go to the store, you put something on layaway, you establish a payment plan, something along that lines. And, they took the position anyway that those contracts were not enforceable until a person turned 21. And they also took what was a logical leap from that a gun store or a gunsmith would not take the risk to make that type of sale. Now,
and this is a different argument, right, than we've seen to justify these restrictions in the past, because a lot of those, and including at the panel level in this case, they relied much more on later restrictions during like Reconstruction era bans on age restrictions for people carrying guns or owning certain types of pistols and so forth, right?
That's correct.
So this is a new it's something a bit unexpected. You hadn't really seen this before, and you actually have written a piece that we will publish at the Reload that kind of tries to counter this view from the 11th Circuit by pointing to other historical evidence. Is that right?
That's correct. I've done a lot of research on this issue, and there are a few issues with the opinion. For one thing, and this is sort of outside the scope of the research you were talking about, but you can just simply go to the store and hand them money, right, for your firearm, and then the transaction's over. So there's no contract in any practical sense.
Yeah, in other words, there also weren't any laws that actually banned anyone under 21 from buying a gun.
And I think that's a big reason why they relied upon this, because they didn't have any laws to rely upon. Yet at the same time, the judges at the 11th Circuit that were in the majority, they needed to find something from 1791 to justify their ruling, because there were actually Republicans on the majority. And a big split in the courts right now is, what year do you look to for historical evidence, or whether a firearm? And a lot of the Republican appointed judges are uncomfortable using 1868, which is what has been used in, what are courts that are have more Democrat appointees, i.e., the Second and Ninth Circuit, have used as evidence. They just the Republican appointees, it appears, are uncomfortable using that time period, and since there are no laws from 1791, everything they had to look to something, and the right to contract was what they found.
Right. Yeah, because the Supreme Court in Bruen, right, they discuss this idea of the historical tradition, and that they don't actually answer this question, right, of when the cutoff point would be for a law that can serve as an analog to the modern regulations. But they do talk about how laws closer to the ratification of the Second Amendment are going to be presumptively stronger evidence, right? So the courts, like you said,
that's actually contrary to what the Second and Ninth Circuit has said. Both the Second and Ninth Circuit give equal weight to the laws of 1868. And just in case viewers are wondering, 1868 is the year the 14th Amendment was ratified.
Right.
And the idea is, since the Second Amendment, as laid out in the McDonald opinion, McDonald v. Chicago, was made applicable to the states by the 14th Amendment, the argument is that 1868 is just as important because it was the 14th Amendment's ratification day, and that's what brought the right to the states.
Right.
And
that's the debate.
So the other courts have said that we can look to 1868, but only if it confirms a tradition from 1791. So if something's different in 1868 from 1791, we have to disregard the 1868 evidence. Stuff from the 19th century only can be used to confirm an enduring tradition from the time of the founding. And, the 11th Circuit is on that side of the argument, and they just didn't want to go with the Second and Ninth Circuit on this issue, who are willing to say that even if it's something brand new in 1868, we're able to use that as evidence. And to be fair, there are some firearm restrictions on adults under 21 at 1868 that you have to contend with. They weren't complete bans, that's for sure, but there were some restrictions. But if you accept that 1791's the year, like the 11th Circuit did, you can't look to those.
Right. And so, and I would just say, practically speaking, that the 11th Circuit's argument is probably stronger because it's citing whether, obviously we'll get into your critiques of what they're doing, of their logic here, or at least the evidence that you found contradicts with some of what they're claiming. But it, that is citing from the founding era, and that probably would have a better reception at the Supreme Court should it make it there. And honestly, probably one of these cases will eventually make it there, because there has been a lot of disagreement on age restrictions in the lower courts. But, regardless, it does feel like a stronger argument under Bruen than some of these previous ones, some of the other ones you discussed, where they're looking at later traditions. So let's get into what you found to be the deficient about the 11th Circuit's argument. What was the main problem with it?
The main problem with the 11th Circuit's opinion is it's premised upon a pretty faulty premise. So it is true that young adults, that minors did not have a right to contract, but there was an important carve out for that, and that was for necessities. Mm-hmm. A necessity is something that you needed to maintain your station in life. That's the language the courts used around that time frame. And unlike it wasn't a bare necessity. The 11th Circuit made it sound like we're talking about food, water, shelter, clothing, and essential
Right.
clothing too. You know,
Because they did note the necessity exception in the ruling. They just thought it was limited to a very small amount of things.
And in reality, it was a much broader doctrine. A necessity was anything you needed to maintain your life, right? And maintain your station in life. Do the things that a normal person does for your age, socioeconomic background. For example, a wedding ring was a necessity because, a marriage is part of your, maintain your station in life as say a 19 or 20-year-old in that time frame. So the courts found that, if you're buying your fiance a wedding ring or other type of jewelry associated with marriage, then that's something that would be a necessity. And the important thing is that means that your contract to purchase the wedding ring was enforceable in court. So if you decide to void the contract or not pay, then the merchant that sold you the wedding ring could sue you in court to get the money that he was entitled to. And that's true with a lot of other areas. For example, a livery, which like military uniforms were found to be necessities. You don't need a military uniform to survive, right? But the courts found that they were necessities because, serving the military, even in one case, it was just a volunteer corps, was, part of maintaining your station life, being a productive member of society, essentially, right? And in sort of, this is what I'm about to tell you is an English case, but it's an English case from 1800, or maybe 1804, I should say, I found a case where a servant for an officer was deemed a necessity, assistant, essentially, right? So this guy's a military officer. It's just natural that he's going to have an assistant and who wasn't. So we're going to find that he's bound to that this is a necessity. So any sort of contract regarding this individual, he's bound by, and so that same reasoning applies to firearms. Now, the 11th Circuit found one example of a pistol not being declared something that was not a necessity, but and they based their whole opinion on that. However, that was an error. A pistol certainly has some function, but there are two important things about the case that the 11th Circuit relied upon. One, a pistol was much different than a rifle or a shotgun, which was called a fowling piece at the time. In 1791, you had to have a long arm to show up for mandatory militia duty in every single colony. And that applied to anyone that was 18 years old. So, whereas a pistol just simply wouldn't have been usable for that. So, at least arguably, a pistol wouldn't have been necessary to maintain your function in life in the same way that a rifle or a shotgun would have been. Additionally, for a lot of people around that time period, they got their food from hunting. It's you don't hunt with a pistol. That's just it's. I'm not saying that you never can, but during that time period with the pistols that they were using, that just simply wouldn't have been an efficient use of your time. The typical person used either a fowling piece, hence the name, it's you shoot fowl with it, or birds, or a rifle or a musket. So those are the arms. Those arms very clearly would have been deemed a necessity. And to look further into this opinion, the court is very clear that we look into a person's particular circumstances when you decide whether something's a necessity. And there's language out there that the 11th Circuit relied upon that said, necessities, food, drink, shelter, basic clothing, right? What the court's really saying there is this stuff, because everyone needs it to literally survive, to not die. We don't need to do a deep analysis because, who doesn't need food, right?
Right.
But, and with other things, say like that wedding ring that I brought up, we're going to actually take a look at this person. Is he about to get married? Is he married? Or is he single and just bought a girl a ring, right? And we're going to make a fact-based determination on whether this person actually needs to have this item in order to maintain a station in life. And that's the analysis that was used in the case the 11th Circuit relied upon. This guy had bought a saddle, stirrups, a pistol, and a couple other things. And after looking into this fellow's particular circumstance, he didn't need any of those things to maintain his function in life. Whereas another person very easily could have been had a pistol deemed a necessity. For example,
like a cavalry officer, I guess, right?
Yes. Let's say someone's an officer in the militia or someone that is serving the cavalry. Now, that's a mandatory arm for a cavalryman. And an officer.
And saddle, too. Would make sense.
Exactly. And so that's... So, there's just a big difference if you just want to have that pistol recreationally, and
right.
you don't, you're not going to use it to hunt, etc.
Right.
But
so your basic view here is that the 11th Circuit came to this conclusion that anyone under 21 at the founding couldn't enter into contracts to buy things that weren't considered necessities, and they only thought that the basic, the bare necessities of life, as the was it the Jungle Book, as they put it in there, were the only things covered by that. But you're saying that if you look closer at these rulings from the time and similar ones, that really what the standard the courts had used for necessities was not bare necessities. It was also anything that would be necessary for somebody to maintain their life as at least their station in life.
Yeah, that's exactly right. I mean, there's another case where furniture, for example, is deemed a necessity. And, I've got further evidence from bankruptcy law from that time. In bankruptcy law, they used a very similar standard as in this necessity doctrine for contracts. And in bankruptcy law, the court could seize your goods, and they would, unless they were necessary for maintaining your life. And the court's very clear that this wasn't literally what you need to survive. This is, things you need to get by in life. For example, a stove, for example, is something that I found in a very early 19th century case where the court said, you can't, your debtor can't go, the collection agency can't come after your stove because you need that to cook, right? That's necessary. And in that same opinion, they expressly say that at least some circumstances, arms are necessities. So
okay, so they say that specifically in these bankruptcy records.
Yes, sir. In fact, there are laws that also there are actually laws on the books, not just court opinions, but there's laws on the books that exempted some arms from any type of collection action, right? And that's applying the same legal standard that was used in the necessity context.
Okay. And so the idea here was at the founding era, while those under the age of majority, which would have been 21, couldn't enter into contracts for certain things, they could enter into contracts for necessities, and among those at the time, what a necessity was would kind of be determined based on their individual circumstance, but very likely that would include at least basic firearms for hunting and militia.
Yeah.
I mean, people also had a requirement to be available to serve in the militia, right?
Yeah. So, I mean, I think that there would have been a universal right to purchase a long arm through a contract because every single person at 18 years of age had to serve in the militia. It was a requirement. And as part of that, people, need to train with their militia arms. And so that would have been deemed a necessity. Therefore, if an 18-year-old entered into a contract to purchase a long arm that was suitable for militia use, that would have been absolutely deemed a necessity. And that applies to essentially every single 18-year-old young adult at during the colonial era, because this is universal.
There are also laws that required, as you brought up in your analysis, that people be armed when they went to church or large gatherings out of sort of a communal safety.
Yes, absolutely.
Concern.
So church was a place where the entire town would be at. And there was a legitimate fear of Native American attack or just simply bandits or something like that, where the whole community is in one location. And if you were armed, the whole town would get wiped out. So not just in church, but some other large gatherings, people were required to bring firearms. And if they didn't, that was a finable offense.
Okay.
Right.
So essentially here you have this corresponding record from the time of people being required to have arms in order to serve in the militia, people under 21 being required to have arms in order to serve in the militia, being required to needing them for, basic survival in terms of hunting and self-defense. And then also, there were other requirements like community defense in these laws that require people to be armed at large gatherings or at church. And so that implies at least that this necessity standard, which looked at sort of it wasn't based on just the very basic food, water, shelter concept. It looked at the individual circumstance and so at the very least for everyone under 21, 18 to 20, perhaps, we'll get into the bottom limits of this in a moment, but, for just your average person under 20, average adult under 21 would have been viewed as needing those as necessities and therefore could have entered into contracts, despite and that there may have also been circumstances where even, for one person, a pistol may not be viewed as a necessity, like the case that the 11th Circuit cited, but for another, it could be, depending on their circumstances.
Yeah,
right?
that's correct. So fundamentally, the 11th Circuit relied upon one case about a discrete type of arm, i.e. a pistol, that wasn't suitable for most of the activities that young adults were required to engage in, and said, based upon that, this is our evidence that firearms as a general matter were not deemed necessities. That's just simply fundamentally incorrect based upon just the case law, the history, and just the reality of colonial America. Okay.
And, so I guess that gets to the question then of like, what is the bottom limit to this? Like what age would have been considered too young for somebody to buy a firearm at the founding? I mean, I guess there weren't any specific laws that related to that, right? But
no,
is there anything in the record that like points to an age that this sort of this record that we're talking about here of necessities and contracts and bankruptcy and so forth, or is it something
I haven't come across a specific age yet. I mean, I think there's some practical considerations Once you get to a certain age, you're not going to have access to money, right?
Sure.
But I haven't. But no, I mean, there's nothing.
The bottom line is less clear.
Yeah.
I mean, this is another, because honestly, the standard sounds like it was very individualized on this point, like what the individual person was considered to need as a necessity in their life. And so maybe that was also how they looked at it for age. Do we know it? Is anything concrete
absolutely
to go off of
there? No, you're absolutely right. I mean, we're talking about people's individual circumstances. So if you get to a certain age, a firearm isn't going to be, if you get young enough, eventually a firearm is not going to be a necessity, or more to the point, it will be accepted that maybe the firearm would come from, some sort of familial relation,
Yeah. Well, I guess they had age for the militia, right?
Absolutely.
They would have age limits on who could join or who was required.
No, that's what I'm saying. I mean, below the age one could serve in the militia, I mean, there would be a argument that that firearms were not a necessity. But once you got to militia age, I couldn't see a real argument that these weren't necessary to maintain your station in life.
Okay. Well, we will. That piece will be out on the Reload, so people should go and read it and look at your citations and some of these cases that you pointed to. And maybe if anyone, I assume you're still looking for more examples, because any additional examples of somebody entering into a contract like this for a firearm under the age of 21
absolutely. I'm useful. Look, I'm a solo practitioner. I only have so much bandwidth to conduct research into colonial history. And, I've got the pretty standard research engines that lawyers have. And that, unfortunately, is not as in-depth into colonial law as I'd like it to be. So, especially if you're a law professor or maybe just a very intrepid law student that wants to spend a little bit of time on this, and you find additional evidence that a long arm was a necessity. I know it's out there, and I could very much you'd very much be helping both myself and the Second Amendment movement if you spend some time on this. So please feel free.
Sure. Well, so this we think this issue, at least, maybe, whether it's this 11th Circuit case or your case in the out of Hawaii or the Fifth Circuit case, there's a lot of these cases at the moment that are ripe for the Supreme Court to potentially take up. It seems like with the amount of disagreement at the lower levels, they may well eventually address this. But perhaps before that happens, you have another case that you just submitted cert for right at the Supreme Court, right?
That's correct. I have a case. I'm on a petition for certiorari, which I'm asking the Supreme Court to grant it, called Wolford v. Lopez, and that deals with Hawaii's sensitive places law. In Wolford, the Hawaii legislature, in all its wisdom, I spent 10 years litigating a challenge to Hawaii's effective no-issue policy in all counties, called Young v. Hawaii.
Yeah, and, for concealed carry.
Yeah. I went to the Supreme Court on that. We went after the Bruen case. So Bruen gets ruled on. Supreme Court rules on mine. And, thankfully I prevailed there, based upon the Bruen opinion. And anyway, long story short, Hawaii had to start issuing CCWs, and it did not like that. So what they do, they passed a law that bans carry. My clients live in Maui, and in Maui, they passed a series of laws that prohibited carry, even with the CCW, in 96.4% of the county of Maui. So, that was a common response you saw in a lot of these states that were forced to change their concealed carry permitting regimes.
Although I
was
think
done,
this Hawaii one is maybe one of the most aggressive forms of these new
so
sensitive
this was
places.
done as part of national movement on behalf of by they obviously coordinating with New York, New Jersey, Maryland, California, and I actually don't think Massachusetts passed one, so I think those are the states. It's a very egregious form of it's a very egregious violation of the Second Amendment because Bruen says you have a right to carry a gun for lawful self-defense. And as a practical matter, when you've banned carry in 96.4% of the publicly available, publicly accessible space in an area, well, how are you possibly going to be able to carry it? Even within that remaining, 3.6%, which is effectively the sidewalk in the road. Now if you want to go anyplace, you got to figure out some place to store the firearm. So, it's effectively turned into a no carry place. Now, there is there is one law that they've we call it the default rule, or as one of your other legal consultants, Costas,
Legal, another gun rights lawyer.
There's a split of authority right now within the legal community on which of these names are going to prevail.
Well, and they call it the vampire rule because you have to be invited in before you can legally carry somewhere. Yeah.
So you have the law that says a business owner needs to put up a sign before a CCW holder can carry in their premises,
right. Which is how vampires work, right?
Exactly.
They can't enter unless you invite them in.
Yeah.
So this case, obviously the court has a couple of these cases too, these sensitive places cases, and you very well could be the one that gets picked. But what I'm interested in your thoughts. Well, first off, what you just give a little bit of insight in what it's actually like to file cert to the Supreme Court. I think you have people don't necessarily know this, right? But you have a whole book that you have to send.
It's actually a fairly costly process because this is the petition for writ of certiorari in Wolford v. Lopez. You don't just file a brief like you do in a lot of courts. You just print it out on 8x5. You actually have to get printed a book. Now, it's a pretty thick book. It's a nice book, and there's actually very specific formatting requirements on not just the cover, but throughout, And these are very specific, requirements that need to be followed that most attorneys don't need to follow. Most attorneys don't have the capacity to, bind these in a very specific manner that the Supreme Court wants. So, what you do is you go to a couple of printing companies, only a handful in the whole country that prepare these, and you pay them to print them out, and the Supreme Court requires 40 copies to go to them, so they can pass around the clerks and Supreme Court justices during their conference. And then you send 3 to your opposing counsel in the mail. And
not cheap.
No, it's not cheap. And but it does make for a nice accessory for the coffee table, though. I have to.
Yeah,
makes you feel legitimate, right? It's like, here's my Supreme Court.
It cost me $10,000, and they denied the case anyway. But so I'm interested in your point of view too, as sort of a working lawyer, I guess, somebody who's directly dealt with a bunch of cases in the Post-Bruen space here.
And
what have you experienced so far in the Post-Bruen landscape? what do you think the court needs to address, given how things have gone since they handed that down?
Well, I've encountered a couple things that one, I've seen a lot of governments get a lot of, let's call it like overreach in their pushback to Bruen. And, I've won a few cases where, this is one, someone actually took a look. It was just so obviously unconstitutional that the other side had to settle. For example, the Big Island of Hawaii had a policy where you had to sign a waiver where you waive your attorney-client privilege and all your other privileges, the attorney-client privilege sort of being the big one and marital privilege, in order to carry a gun. And they thought that complied with Bruen. And what the idea was, they could get, what if you managed to, you were charged with a crime, but you had a really good lawyer. They want to be able to look at the criminal files of your attorney to see whether there was any evidence that you were unsafe to carry a gun. Now that's a little bit beyond the pale,
Yeah.
That will have also given them access to business records and professional trade secrets. Even though that's not what they were saying they wanted it for, it was just a broad, waiver. And that's a situation. Once the attorneys got involved for the county, it's like, well, this is a little bit too far. We're a little bit worried about this. Police chief, next time you think about doing something like this, call us first. And, there was some settlement. Another issue is not necessarily pushback, but law enforcement is not prepared to issue the permits logistically. They just don't have enough staff. They don't have, the mechanism in place to efficiently process a large influx. So I had another case in Honolulu where my clients have been waiting for over 1 year for their CCW applications to be processed. And, nothing wrong with them. They just big backlog. So I filed a lawsuit. And, bottom line here is the county hadn't appropriated enough money to let the police department process these things. And they were just sitting on these things indefinitely. I had a gentleman who'd been waiting 18 months. And, that's another thing where it's not necessarily intentionally restricting the Second Amendment right. They just maybe don't care that much, and they just are not set up on how to do it. And that's another thing. And then, there's been a lot of other challenges, that are people just not really knowing. Maybe there's an effort to try and comply with Bruen, but people don't really know how to do it. And the courts are having some issues knowing exactly what they need to do to determine whether something's constitutional or not.
Yeah. And so I guess that's the next, I don't know, how has the standard really been viewed by a lot of these judges in the cases that you've litigated? Like, do they, because you've heard a lot of complaints from, at least from maybe your more left-leaning judges on the standard itself and it being, this history-based standard and it's too hard to apply in practice. Have you heard that?
I've certainly heard that to a degree.
Yeah.
And, I have a case in DC right now where, the judge has suspended page limits on our briefing because she wants us to submit. She didn't say this, but this is clear. She wants us to submit as much as possible, both sides. She wants as much history because, she probably doesn't know exactly how she wants to apply the standard yet for Bruen. So she'd rather err on the side of, getting as much information as possible. I've had other judges that they're making a good faith effort, but it's still very early on, and this is not an indictment of Bruen. This is just an indictment of change. After
Sure.
Brown versus Board of Education, I mean, there were several years, easily a decade, of lower courts just not knowing exactly what to do now. And that's just true
Right.
whenever there's a sea change in the law.
Hmm.
So,
So do you, the court's done one case where they've kind of, where they've at least applied Bruen in Rahimi, right? I assume you would hope that they continue to do that, so they kind of whittle down exactly how to apply this and where sketch out the limits on either side.
yeah,
That
no,
was kind of
absolutely.
seemed like what Rahimi was doing, was sketching out the limits on the straitjacket. So to speak, they said this is neither a blank check or a straitjacket, and Rahimi kind of puts the straitjacket side of things in context for the majority of the court, at least.
Yeah,
And then they haven't done anything on the other end with the blank check side, right?
yeah, I mean, that's
just
what
think
the
they
court
need
needs
more.
to do. I mean,
Yeah.
if the court doesn't take cases, it's going to drag out this period where the trial courts are just having a real issue on how to exactly apply the standard. There needs to be a lot more cases taken. I'm hopeful right now that the Supreme Court will take the Snopes petition. The Snopes petition is
Maryland's assault weapons ban. Yeah.
Yes, assault weapons ban. That's currently before the court. In my case, there's a circuit split between the Second Circuit, that's the New York courts, and my court on the default rule issue. And so I think that's a prime candidate, and I don't think it's controversial, really, that law. And the fact that
You think it should be pretty straightforward for them to strike down the ban?
I'd like to think so.
Yeah.
But I mean, when you have the Second Circuit, which is not a conservative court, striking down law, and you see the Ninth Circuit with identical history and identical law upholding it, I mean, that's a very clear indication that the courts need some guidance on this issue. And the Supreme Court does need to give that guidance, or else, there's going to be a lot more opinions saying we don't know what we're doing here.
Right. Well, hey, maybe they will take up your case and we will get that guidance, but that's something we will look forward to covering if it happens. And people, like I said earlier, they should have the reload and check out your analysis piece on the sort of age restrictions and the history of that. And otherwise, where can people find more of, follow more of what you're doing?
Well, I have a professional Facebook page. If you look for Attorney Alan Beck on Facebook, I post some of my filings, and I certainly post whenever we get a decision or some sort of settlement in one of our cases, and so that's probably the best place. Again, Attorney Alan Beck on Facebook.
All right, great. Well, we will have to have you back on once we get some more news in some of these cases. But that's it for now. I'm going to hand it off to myself to tell you guys a little bit about the dispatch. All right, folks, it's time to talk a little bit about the dispatch, doing an ad swap here between the reload and the dispatch. And I think that's fitting because if you like what you're getting from the reload in terms of high quality reporting that focuses on hard news, you'll probably like the dispatch as well, because get this, they also focus on high quality reporting and hard news. Now, they are a much broader publication than the Reload. We obviously focus on one specific area, whereas the Dispatch has a much larger team and is able to focus on a whole number of other issues, but still primarily in that national politics realm like we do here at the Reload. But they are one of my favorite publications. I am a paying member to the Dispatch, and so clearly, I highly recommend it. I've been a paying member since they were founded, and I've never had reason to rethink that even once. So they are constantly breaking news stories. They are sending you newsletters on whatever frequency you want. They have quite a variety of them over there. But I subscribe, for instance, to the Morning Dispatch, and I get, I think, a very nice summary of what's really going on from a pretty sober perspective. That newsletter is hard news, and it's focused on it. And I think it's fantastic. But they also, of course, have some of the best commentators, in my personal opinion, over there as well. You know, it was an outlet founded by Steve Hayes and Jonah Goldberg, two guys I've known for a long time. They've been on the Reloads podcast. Kevin Williamson as well has been on our podcast. So you've heard from these guys if you've been a Reload listener for a while here. And, you know, I think you should check out the Dispatch if you haven't already. We have a free trial as well, 30-day free trial for Reload listeners if you want to go over and check out their paid offering, which I think is well worth the money. So I'd encourage you to do that. There's a link in the description of this podcast or on our website if you want to check it out. So head over to the Reload to get that link, or head over to the Dispatch to see what they're all about.